Hi, everyone, and welcome to The X, a podcast from inside Silicon Valley about how experience shapes everything from products to services to entire businesses. I'm Brian McLean, and I'm here with Demetrius Madrigal. Today, we're going to talk about the patent process. Oh, yes, you heard it right, patents. How does it work? When do we do it? Is it necessary? Can I do it alone? It can feel confusing and stressful, and that's why we have a very special guest today, Phil Wagner. Phil Wagner is a prominent patent agent here in Silicon Valley and works with inventors all across the country. He's been helping companies protect their intellectual property for over 15 years and is an expert in this area. He's also become a very good friend of ours, and we're happy to have him on the podcast today. Good morning, Phil. How you doing?
Good morning, Brian and Demetrius. Nice to talk to you again.
Yeah, thanks for doing this. I know you're really busy, and I'm sure there's a lot going on. There's a lot of companies right now dealing with IP and kind of pushing to the next level. I wanted to start this off, Phil, by having you just tell us a little bit about yourself, about your business, and then also explain the difference between a patent agent and a patent attorney, something that I literally knew nothing about until I had met you about 10 years ago.
Well, the 30-second bio is I was a design engineer for almost 15 years doing avionics and data acquisition stuff, electro-optics mostly.
Okay.
And that dragged me kicking and screaming into the semiconductor world, where I ended up starting out as an app engineer and then got into the sales and marketing ends of things. Finally decided I didn't want to live on airplanes anymore and studied patent law 16 years ago now, passed the patent bar.
Okay.
And I've been writing patents and prosecuting patents ever since. And I really love it because I end up meeting a lot of incredibly innovative people. And I'm just sort of a people person, so I like exploring technology and exploring what they're doing with their products. I'm a patent agent. A lot of people are curious about the difference between a patent agent and a patent attorney. As far as the United States Patent and Trademark Office is concerned, there is no difference. We both have to have the same set of credentials to apply. You have to have a degree in science or engineering to apply to become a patent practitioner. Then you have to pass a rather extensive patent law examination, which I did quite a long time ago now. Mm-hmm. And then you get a registration number from the patent office, and you're authorized to interact with the patent examiner core and to represent clients before the patent and trademark office. So both agents and attorneys have to go through that same process. The difference between an agent and an attorney is I am only authorized to practice patent law. An attorney passes a state bar and can practice state law. So they can do contracts and other things. I don't get into any of that stuff in my business. I just work on patent law.
I see. So I have a question about that. So you were saying that you have to have a degree in engineering or science. Where do they draw the line usually on that? Meaning, like, if I have a degree in like chemical engineering, can I still help people with other forms of inventions and things that are not related to like chemical engineering? Do you know what I mean?
Sure. In fact, that's where my degree is, chemical engineering. Okay. It turns out that the Patent Office doesn't make any attempt to enforce the area of competence of the practitioner. However, it's up to the ethical rules that we subscribe to at the Patent Office to maintain our registrations that we have to present to our clients that we are competent in the areas that we represent them. Oh. So, for example, I will engage in patent applications on mechanical, electrical, electronic, semiconductor, optical, medical devices, things like that. But I will not engage in chemical practice, so things like pharmaceuticals and stuff like that, because I'm not really a chemist, and I don't want to get into attempting to write applications in those areas. But in the areas that one is competent for conducting the preparation and prosecution, you have to be able to understand the prior art references that are cited against an application by a patent examiner. And if you can't understand the references, then it's not an area that's a good area to practice in.
Got it. And one of the things that has come to mind over the years of getting to know you and working with you is that, in my opinion, takes a very specific mind to write patents. And I tried sitting down and really exploring like the way that you do prior art and the really like subtle differences between certain patents and stuff. And I remember sitting with you at one point and saying, like, I think this is the difference of this one and this one and that one. You're like, hey, that's pretty good. But like, here's really what's happening, and why this appears to be a different product than this product. Uh, how do you sharpen that tool? Like, if someone was like, I want to do what Phil does and I want to become a patent agent, like, is it just that because you've had experience in engineering, marketing, and the training that you can figure those things out? Or is there a certain, I don't know, mindset that's required in order to
I
go down
think
that path?
I think there is a certain approach or a certain attitude. First of all, if you want to be a good patent practitioner, agent, or attorney, um, I think it really helps if you like talking with people. In my past experience, when I was in sales and marketing, I would talk to, a dozen people a day that I hadn't met before. And, we're talking 50 or 100 people a week. And you get comfortable with talking with people. And in the sales and marketing role, you get comfortable at exploring what their needs are and how you match or don't match what they need. That aspect is very similar to what happens when I'm talking to inventors. A lot of inventors, really quite unlike you guys, for example, they're rather hesitant to talk. And so you have to kind of offer some encouragement and display some genuine interest in what they're doing. And it gets people to open up. And then after that, it's the experience in knowing what's needed at the patent office as to how you guide that conversation. And I think that's what you mentioned a couple of minutes ago. I was asking you things that you weren't thinking about.
Yeah.
Because what I was thinking about was, okay, what do we have to prepare for when I write the claims to this application? And how do we know what might happen when the examiner starts citing prior art and so on? That just comes with experience. And that's, how do you know the difference between, I'll say, a new engineer and an experienced engineer? They just follow a different pathway to get to a solution. And it's the same in patent practice.
Yeah, it's one of the things that I actually really appreciated working with you. It was the first time, I used to work at NASA, and we had patent agents there, and they were very, they have a lot of patents like every day, I guess, that they're working on stuff. So they just kind of would come to me and ask for very specific things from our lab, and then I would just deliver it to them, right? There wasn't a big conversation happening. Let's put it that way. I didn't get to know them like I got to know you. And one of the things I appreciated working with you is that you would explain to me things in plain English. Is like, oh, the reason why we have to file this paperwork, or the reason we have to do this. I wonder if, because you do that, you made me feel more confident and comfortable about the patent process, where I talk to other friends that are thinking about going down the path of trying to get something patented, and they feel very overwhelmed when they're reading, all the text online about like what you need to do and how you need to do it and what could happen and what the process is like. So I guess I should start here and say, like, if you're that person, you're an inventor and you're having this anxiety and you're trying to figure this out, why do we need a patent? Let's just start right there. Like, why is it necessary for them to go down that path rather than just building something and trying to take it to market and sell it?
Well, there's as many different reasons for why you need a patent as there are marketing strategies for products. So let's start maybe to establish some common ground here. Let's start with what a patent is and what it's for and what it's not for.
Okay.
So that'll help us get to the point where we can say, so who needs this and who doesn't need this? In the United States, an issued patent is a property right. It's granted by the federal government to the first and original inventor. They can have invented a process, a machine, an article of manufacture, a material, or some new and useful improvement in any of those areas. But the key thing is patents have the attributes of personal property. So, for example, you can buy and sell patents, you can license them, and so on. What a patent gives you, if you manage to get to an issued patent, a patent gives the patent owner the right to exclude other people for a limited time from making the invention, using it, selling it, or importing it into the country. And on top of that, a patent and sometimes even a well-executed patent application, it can have economic value in its own right that contributes to the financial assets of the patent owner. But patent rights have limitations. Patent rights expire after a fixed period of time. Now, in the US, that's 20 years from the filing date of the first application that led to the issued patent, because sometimes you can file a string of applications that get to the patent, and we'll talk about that later.
Okay.
But patent rights also have geographic restrictions. So patent rights are enforceable in the country that issued the patent, but not in other countries. So a patent issues in the United States is enforceable in the United States, but it's not enforceable in Canada or Germany or China. So there's no single patent that's enforceable everywhere. There is a unified patent application process that allows you to submit patent applications to many countries simultaneously. It's called a PCT application, or Patent Cooperation Treaty. But at some point, you still have to decide which countries will you enter that application into and then pursue the patent in country. And another thing about patent rights is that they have to be enforced by the patent owner. The USPTO, the Patent and Trademark Office, doesn't get involved in that. Nobody's going to police the market for you and look for infringers or help you decide if someone's actually infringing or not. You have to do that on your own, or with the help of legal services that get involved in this. And this is something that may seem particularly odd, but a patent does not give the patent owner the right to build and sell the invention, because your invention may have components or materials in it that were patented by other people.
So okay. So let me just kind of summarize here. So if I patent something in the United States, it's in the United States, but I have to file a separate patent, for example, if I want it to be protected in, let's say, Canada or China
or Germany, or yes.
And then if it's issued and I actually have the patent, then it doesn't give me the right to sell it or create it. It just means I own the intellectual property behind
You own the exclusionary right. And the best model I can compare it to here is, suppose you buy a house. You have the title to the house. You have a property right. Because you have the title to that house, you still can't do anything you want with that house. You may have HOA rules. You may have ordinances that affect what you can do with your property. You probably can't open up a retail operation in your living room and so on. But what you can do is you can stop other people from doing things with your property. So you can control who gets in and out of your house, and you can say who gets to use that property. But you can't do anything you want with it. And a patent is really kind of a similar idea. And you could draw a similar analogy with buying a car and getting the title to the car. Just because you own the car, you can't do anything you want with it. You still have to follow other laws. And so patent rights are kind of like that sort of property right.
So one of the things that I noticed that you said there was that the United States Patent and Trademark Office does not defend your patent for you. And I think that's a key thing for people to understand, right? So if a patent is issued and someone infringes on that patent, I'm going to have to financially cover the cost of getting experts and attorneys and everyone to help stop that competitor from creating a product that I had patented. And that's going to be a cost on me.
This is where you get an attorney involved, because now you're getting into property law in the state that you're in. But normally what will happen is you approach an attorney, and preferably a patent attorney, I should say, because they will understand the implications of the patent. And that attorney will talk the situation over with you. And what they might do is send a letter to the alleged infringer informing them that there's either a pending patent application or an issued patent in existence on the thing that they're trying to do. And because a lot of people, they might just not know. They might not have any idea that they're doing something that's patented.
Yeah.
And so, it's kind of a courtesy to just politely inform them, hey, wait a minute, you're kind of getting into something here that's affecting me. A lot of times that letter will be enough to get them to engage in a licensing conversation.
Got it.
But if they decide to pursue their activities regardless, and you eventually get a patent, and now they've engaged in something called willful infringement, and the potential penalties are substantially higher because
Okay.
they had been informed and they did it anyway.
Yeah.
But you have to pursue that through a court.
Yeah. And I hear all this though, and what comes to mind is this little worry. It feels very expensive, Phil.
It's like defending any property right. So yeah, if you're going to get legal services involved to defend your property rights at your home or for some other thing or for your patent, for your
Yeah.
business, there's going to be expenses associated with that. So that's whether or not you engage in that depends on the size of the market and the potential revenue stream that you're trying to protect.
Yep.
I think later on we'll be talking a little bit about reform, and we'll get back to this subject.
Yeah, absolutely. So let's just say I'm in my garage, Phil, and I come up with this novel idea and I'm using duct tape and, cardboard and things like that. And I pull together some product. What do I do next?
Well, basically, what you want to do is as soon as you think you're doing something that you're going to want to take to market and you think it's a new thing that nobody's doing it before, because after all, a lot of inventors are pretty expert in the field that they work in.
Mhm.
They know what else is out there, and they know why they're doing what they're doing. They know why they're investing their time and money to do something that they don't think has been done before. At the point where you realize, wait a minute, I've got something here, that's the time to go find a patent agent or a patent attorney and sit down and talk to them as early as possible and map out a strategy for IP protection. Those early conversations, at least with me, and a lot of patent agents are like this, and so are some patent attorneys. A lot of those early conversations, a lot of people don't even bill for them. So they're just trying to find out, should we be working together? And so don't be afraid of calling somebody and explaining the situation and saying, maybe we should talk a bit more. In my own case, I don't charge people for those conversations because I want the inventors to find out, am I the right guy for them? I'm not always the right guy.
Yeah, that makes a lot of sense. I think the confusion always comes in of like, well, how far along should I be with this invention, right? So like I've had colleagues and friends say, well, this thing I invented, no one else has ever done this before, but it's, pretty much like duct taped up, right? Should I be actually creating a SLA printed prototype so that my patent agent or my patent attorney can like really feel it and see what it does and see it function? Like that, there's that gray area there of like, how far along do I come? What would you recommend
Oh, well,
somebody do?
if an inventor has made toys, I love playing with toys.
Okay.
So it's just such a cool way to explain how something works. But as I said, at the point at which the inventor has an kind of an operative grasp of what the thing will be, he or she doesn't have to have built it yet. But you know what the objectives of the invention are. You
Okay.
know what its main features are. You know its operational aspects to at least some level of detail. At that point, go talk to somebody. What I really recommend against is for inventors to put very much time at all into trying to figure out how to patent it itself. And we're going to talk, I think we should talk more about that in a little bit later. It sounds, when I just mention it like that, it sounds self-serving, but there's some real implications here. Basically, as soon as you get to, even a crude prototype or a schematic diagram or a block diagram that has enough information in it that tells you how is this thing, at least at the view from 20,000 feet, how's it going to work?
Okay.
That's the time to talk to somebody.
So yeah, so what I got from you is like, what are your objectives? What are the features? How does it function? Like once you feel like you understand that, then you get that conversation going as quickly as possible. Once that conversation begins, what happens, Phil, if like a month down the road, you've started this process of patenting it, and then you've changed how it functions a little bit?
Well, this is where we want to get a little bit into the process of how you get a patent.
Okay, okay.
So basically, once you get that operational level of detail, at least you kind of have to follow the 80-20 rule here. You don't want to delay this until you know 100% of everything. You want to get 60, 70, or 80% of it. At that point, you file. You talk to somebody about preparing and filing what's called in the U.S. a provisional patent application, and a provisional patent application captures the features of the invention that you want to protect. It has sketches or drawings. It has a written description of the invention. It doesn't have a controlled format, so it could even be as simple as a PowerPoint presentation that you're about to give a prospective customer, or a white paper, or something like that.
Okay.
But it's better if it has more detail in it than that. Because what you want the provisional application to do is to have a descriptive, a functioning descriptive content on what will be in the claims in a future non-provisional application. And again, you want to get that provisional application filed as soon as you can, because it establishes what's called the priority date of the invention. So later on, when the non-provisional application is being examined by a patent examiner, that priority date sets the date references that can be cited against the application. The patent examiner has to find prior art that predates your priority date to attack the claims in the non-provisional application. That's why getting that provisional application filed quickly is so important. The other thing is, once you file the provisional application, as you're making improvements, just file more provisional applications. They're inexpensive. And then before that 1 year date from the first one, you roll up all of them into your non-provisional application, claim priority to all of them. The nice thing about the provisionals is that they can be done very quickly.
Okay.
And
so when you say quickly, like what does that mean? Like a month or something, or like?
Heavens, no. Let's see. It depends on the level of detail and the nature of the invention. So there's no one size fits all here. One way to do a provisional application is to basically write it as if it was a non-provisional application, and just don't put the claims in it, because the claims are one of the more expensive parts to write. Okay. But you write it as if it was a non-provisional. That pretty much guarantees it's got written support and drawing support for everything that's going to be in a future claim. So that's one end of the spectrum. The other end of the spectrum is you fill out an invention disclosure form, possibly provided by your patent practitioner or by your company, and you file that as an application.
Oh, I see. Okay.
That's called some of us call those as is, not provisional applications. We just take what the inventor gives us and we file it. Or we maybe put a cover page and a couple of explanatory paragraphs with it. So you're talking a range of preparation time here from, 2 or 3 hours for an as-is provisional, up through, for a really good, detailed, strong provisional application. It depends on the nature of the invention, but it could be 10 to 15 hours or something like that.
Yeah, that's pretty quick. Have you ever had anybody like bring you in the office and say, "Can you sit right here and write it right now?"
Yep.
Oh man,
those are
stressful.
In fact, some big companies do that all the time. So what they'll do is they'll call up and they'll say, "We've got this invention disclosure form. The guy filled it out yesterday. He's going to a trade show tomorrow. Can you file it right now?"
Wow, that is a lot of stress. You just have to get in there and just dig in.
I have to, yeah, basically the fun part of my job, if you want to call that fun. Uh, I have to go in and I have to read the application because as a registered professional, I have to take on representation of that person. So if there's anything in that application that shouldn't be there, and there's lots of things that shouldn't be in a patent application, I have to get them out. And sometimes I want to stuff in a little bit more explanatory content. But mostly on those as-is provisionals, I'm just taking out stuff that we really don't want in the patent record.
Okay. Okay. So let's go back to that idea that we're in the garage. We came up with this idea. Someone just called you, Phil. You came over. You helped them file a provisional
Mm-hmm.
and submit it. What are the next like obstacles and milestones that they can foresee coming?
Okay, so within 1 year of the filing date of that provisional application, you have to file a U.S. non-provisional application with patent claims and patent figures and a proper written description and the other highly regimented and formatted parts of a proper patent submission to the Patent and Trademark Office. The provisional patent expires in 1 year, and that expiration is non-extendable.
Mm,
The other thing about a provisional application is it cannot claim priority to any other application. So you can't have one provisional application claiming priority to a prior one and to a prior one and so on. Only a non-provisional application can claim priority. And what we do then is we have to take the content of the provisional application plus any new content that the inventors have come up with and write it into the format required for, in the US anyway, for non-provisional applications. Make sure that there's patent claims in it that give the proper legal description of the invention. And a patent claim, it looks like the kind of property description that's associated with your house title. It's almost the same kind of language, and you're giving a legal definition of the invention so that somebody reading that claim, they can definitively state, is another object the same invention or is it different? And the patent claims are meant to have that kind of a bright line boundary around them.
got it. So you said something earlier which kind of caught my attention. You said that the once you submit a provisional, it's kind of like prior art. If you abandon your provisional, like you after a year, you're like, we're not going to do this. And someone comes in with a similar idea, which a lot of people have similar ideas, is that art stay in the patent system?
Oh, that's a really cool question. Yeah, so first of all, you don't abandon provisionals, they just expire. They're
Oh,
going to
okay.
expire whether you do anything or not.
Okay.
However, and the other thing is, provisional applications generally are not published. They can be published when they're in the priority claim to a non provisional. But in and of itself, it isn't going to be published. However, under US patent law, a provisional application, even an expired one, on the day that it is filed, can be used by a patent examiner in the future as a definitive evidence of that which is known in the art. So
Wow.
an examiner can cite a provisional application against somebody's non-provisional application, even though that person never could have seen the provisional because it's not published.
Yeah.
But the examiner can legally assert that, the day after that provisional was filed, it now represents that which would have been known to a person of ordinary skill in the field of the invention. It's
Wow.
just one of those weird things of patent law.
Well, what's interesting about that is that if I do that, then someone else coming in who wants to like pick up the ball and run with the idea that I no longer want might have some hurdles to get around because those drawings are now in their system.
You bet. And in fact, that's one of the best uses of a patent application. You don't always want to stop with the provisional to make it really effective, but you can seriously interfere with a competitor's ability to enter a market by preemptively filing patent applications and blocking off channels that they might pursue. This is a very common tactic. So if you think a competitor is going to get into your market, and what they're going to do is they're going to take your design or some other design and they're going to add an enhancement to it to get around the patents. If you can figure out what you think they're going to do, you file a patent application on it first. The thing is, you still have to explain how to make and use it. You still have to explain, what the thing is. But you can seriously put pressure on a competitor that encourages them to come to you to license.
So it makes sense then early on when you said, like, the minute you have an idea and you feel like you understand how it works, then you call somebody and you get it.
You can do that. And now, why it turns out that even very big companies don't always do this. And the reason is most inventors and most companies in a business context, they have many more ideas than they have revenue to pursue.
Oh,
so what you want to do is make sure you're covering your own bases first. Make sure you're defending your own market first. If at that point you have funding to pursue these kind of defensive patents, that's a marketing strategy. And it's a very powerful one, but a lot of companies use it in a limited way. They'll get an engineer, an engineer's idea or a scientist's idea, and they'll file a patent application on it. And then later on, after the application is in examination, they decide whether or not they want to continue the prosecution.
I'm listening to all this, Phil, and I'm thinking to myself, can this be done by yourself? Like meaning, could I sit down and like fill out a patent application and do my own drawings and do everything? Is that even possible these days?
Yes. The U.S. Patent and Trademark Office allows what are called pro se applications. An inventor can fill out their own, they can write their own application and fill out the necessary forms and pay the fees and file it at the patent office. And they can do that for provisionals and they can do it for non-provisionals. However, I have to be careful how I talk about this because I don't want it to seem self-serving. But I cannot recommend against that strongly enough.
Yeah.
Patent law is very complicated. You're simply not going to pick up anything other than a very high-level view of it from some of the popular books that are out there on the market. I won't name any of them, but there's a couple of them that are used over and over again. The problem is that those books do not teach you what is likely to happen during the examination process. So if you don't know what's going to happen during the examination process, you will not put the right content into the application.
Yes.
And you kind of touched on this earlier when you said I was asking you some strange questions. When we were talking about your new inventions. The problem is patent application is not an engineering paper. It is not an engineering presentation. It is not a marketing presentation. It is its own thing. So the way you would write a marketing spec or an engineering spec or a scientific paper, that's not how you write a patent.
And I'll tell you, Phil, like most of the people that I talk to about patents that have never done it before, they thought that it was an engineering document. Like when we started,
it's a legal document.
Yeah, but you kind of read some of the, the claims and things like that online, and you go like, oh yeah, they're talking about the engineering of this particular device. It's not the same. Yeah. And I think that's so great for you to say that, because people have to understand it's basically like, would you say it's a blend between legal and engineering together?
Yeah. And that's why how do I put this? There are not so many people like me out there. How many engineers like writing? Now,
True.
I do. I wrote a lot of stuff when I was an engineer. I wrote technical papers and I wrote seminars and I did a lot of stuff like that. And I found out I liked it, which was a real surprise to me because when I was in college, you couldn't get me to write a paper except to get a grade.
Yeah.
But I found out I liked it later on. And most people don't like the writing, so they don't put the time into it. And there's a craft element to it. But in patents, there's a rather deep pool of knowledge that you have to absorb to do it credibly and competently and with a good outcome at the patent office.
Now, do inventions require like multiple patent agents to be working together on it? Like, you know how like teams of engineers will work on a project. Do you ever get in a situation where you have to have like a team of people trying to address a new
That's
invention?
that's rather unusual. I won't say that it never happens, but it's pretty unusual because what's more likely is in some law firms they'll have one person write the application and another person review it,
Mhm.
and what they're going for is a kind of check and balance system and cross check and proofreading and why did you do this and why did you do that. That can actually be valuable, but you kind of get a problem where you get too many cooks in the kitchen.
Yeah,
And a patent that's been written by more than one person, it normally kind of stands out because it doesn't have the continuity. And it might not even have a unified strategy for how the claims are structured and how the content is presented. So most patent preparers, although they may work in a team environment, they're going to be writing the applications more or less on their own.
I see. So this question kind of popped into my mind as we were talking about this stuff. So if I go off and I go through this process and eventually my patent gets issued and you have this celebratory day of like, oh my gosh, our patent got issued. Am I required to bring that product to market or anything like that? Is there any requirements on me?
You can put a plaque on your wall and forget it.
Okay.
One wonders why you might have spent all the money to do that, but some people like the recognition, and it gets back to the purpose of a patent. One of the purposes of a patent is to establish market credibility.
Okay.
So sometimes what you do is you get the patent because you want a particular target market to recognize your technical expertise in that market. You're a member of that market
Mhm.
because you've got the patents to prove it. That doesn't mean you've actually had any of those things built.
Like, is there a percentage? Like, do you know? Is there like does the patent office give you a percentage of like, 5% of all patents actually turn into real product or anything like that?
I am constantly amazed by how little patent examiners know about what happens to the patents after they issue them.
Oh, okay.
In fact, I am sometimes, when I'm talking to patent examiners, one of the things I do a lot of examiner interviews. That's part of the response process that's available when an examiner rejects an application. And the examiners, I find, are deeply knowledgeable in their technical areas. So I always learn something new about patent examination or patent law or even the technology when I'm talking to an examiner.
Uh-huh.
And for their part, they like talking to me because they just don't know the business side of things. And they want to know what are these inventors going to do with this thing? And in more than one case, I've had an examiner say, when can I buy this thing?
Yeah, yeah, and I actually would imagine that one of the fun parts about this job is the fact that you get to see things that you helped kind of pull together in the early stages turn into something that's physical and real, and you can actually use it. I mean, have you had any successes like that you were
Oh
really
yeah, yeah.
proud about or excited
It's fun to walk into some place and see something in a blister pack on a shelf.
about?
But when I was an engineer, it was the same way. I was doing avionics design, and back when you could still look in the cockpit of a passenger aircraft, I could look in there and occasionally see one of the instruments that I designed, and that was a big deal.
Yeah.
It just you just kind of you just stand up a little straighter when you see something like that. So basically, a lot of the things that I work on, they're components of bigger systems. So semiconductor devices or surgical instruments or mechanical components, whatever. And so they don't often have that kind of out there sort of visibility. Although every once in a while, I can see a piece of farm machinery that I got a patent on or something like that.
Uh-huh. Okay. So one of the other questions I had was that if the patent gets issued and you have the celebratory day and you get your plaque on the wall and everything, can it ever be invalidated after it's already been issued to you?
Yes.
Ooh.
It is possible for someone who maybe doesn't want to pay your license fee, or they have a patent application where yours has been cited against theirs, and they think that yours has been issued incorrectly. A patent can be challenged, and this is happening a great deal right now with software related inventions, because under current law, software is not patentable. So if someone tries to assert a software patent against a potential infringer, one of the paths open to the party that's having the patent asserted against them, they can go try and get that patent invalidated.
Mm,
And there's a process for doing that at the patent office,
yeah.
and it's not a quick process, but there's a formal proceeding that you can engage in, and then a panel of judges will decide. And if you don't like what they do, you can take it to a federal court and see if you can get it invalidated there.
Wow. Okay. Whew. Okay, so I think this is a good time then, because you had mentioned software, to kind of transition over to our next segment here or section. Demetrius and I talked to some of our listeners and some of our colleagues, and we generated some questions for you that they wanted to ask you and see what your thoughts were on it. So the first one was one that you just mentioned right now: is can you patent software or code or algorithms?
Okay, we have to be careful about the language here.
Okay.
Let's say that an algorithm is a general kind of theoretical approach about how to do something. uh, and algorithms as such are not patentable subject matter in the US, and really never have been. Because in the US, what you patent is you don't patent the idea of a thing, you patent an implementation of it. And the idea behind this is that they don't want a patent to block off an entire field of research.
Okay.
So algorithms as such are kind of viewed as laws of nature, and you can't patent a law of nature. Now, software. This is where things get really sticky.
Okay.
Yeah, a few years back, there was a court case. It's now rather famous or infamous. It's called Alice versus CLS Bank, in which it was decided that software as such is not patentable. The decision was that it represents mathematical laws of nature. It just has exploded through the patent systems around the world. The European patenting systems, the PCT and others, when they were set up, they excluded software as such. But that doesn't mean that you can't get a patent to something that has software in it. Um,
Oh,
so
okay.
the idea is the way the patent office rule in the U.S. is written. The claim in the claimed invention has to be to something substantially more than just the software. So, for example, what does this mean? The software can contribute, for example, to controlling a machine or causing modification of a material. The language used in patent law is called the machine or transformation test. Does the software cause something to happen? And that thing that happens has to be part of the claim. So if you're using software, for example, to control a CNC mill moves, or how an airplane flies, or how a car vision system detects a pedestrian, you can definitely get claims to software like that, because you're going to be claiming it in conjunction with the apparatus that it interacts with. So if there's a sensor or a transducer or something like that involved in what the software is doing, that's likely to bring the software into the realm of at least patentable subject matter. Whether or not you can get the patent is another question. You still have to pass the barriers of novelty and non-obviousness. If it's just a software that is just processing numbers, like a database calculation or a communication transaction, those kinds of applications are very, very, very difficult now to get allowed claims for.
I see. Because, like, yeah, the examples that we had when we were having this conversation were, obviously you mentioned one, self-driving cars. There's a lot of technology going into that right now. So that's a big popular area. But also, we were watching the video of Boston Dynamics robots that were dancing the other day. And it was like,
Right.
well, there was a lot of code written in conjunction with, hardware development to make those robots dance. So,
And that's very likely to be an area where almost certainly they can pursue patents, because what's that software doing? It's controlling motors, and it's receiving data from vision systems or radar systems. It's receiving data from pressure sensors. It's driving hydraulics. So all of those interactions, those are not theoretical or hypothetical or abstract ideas. Those are concrete implementations. And under those circumstances, software is at least within the realm of patentability.
okay, got it. Awesome. All right. So, second question was, what happens if you meet with someone, review the product, and have a strong sense that they cannot obtain a patent? Can you tell them? What should the inventor do?
Well, as a patent practitioner, I'm obligated to tell an inventor, a prospective client, actually, if I don't think I can get him a patent.
Okay.
But even if that rule wasn't there, I would do it anyway. I really don't want to see people wasting uh, valuable and limited funding when they might have some other use for it. So, for example, I get calls from people all the time that find my contact information on the Patent Office website. There's just a registry listing of us by state. And more than once, someone has asked me about patenting an invention that I already knew existed. I'd
I see.
already run into it in some other context. And I've just told them, okay, here's what I know about. Go look at this. If this is the same thing as what you're doing, you're not going to be able to get a patent on that. You'll have to find some improvement to it.
Got it. Okay. So, in that case, let's say you told that to the inventor, but the inventor really wants to go down the path of creating something in that space. What do they do next? Should they kind of start over? Should they try to enhance it? Like, how do you process that as the inventor?
Well, now you're asking a marketing question more than a patent question. So, yeah, if there's already something out there like what they have in mind, now they have to come up with a business strategy for distinguishing themselves. And that happens all the time with people that sell commodity items. And now it comes down to things like maybe your trademark is different, your marketing materials are different and stuff like that. There's still IP protection that you can pursue. It's just not going to be on the product itself. And there's still many avenues to protect at least the way you approach the market and the way you present the product to your prospective customer base.
Is that part of your business, Phil? Meaning, like, do you sit down and help them think through, like you said, like the trademark, the marketing side, things like that, if they are kind of in that conundrum, or no?
Sure. Yeah. In fact, during those initial conversations about protecting the invention, that's really the nature of the conversation. It's not just about what does the invention do. It's about what's your timetable here? When do you want to take this invention to public disclosure, and what are your plans for monetizing the invention? How are you going to get some kind of valuation on it, and how are you going to approach distribution in the market and so on? Those all have to come into play in the strategy for what you patent and when, because a lot of startup companies start out with the core features of an invention. They want to protect the core technology, But then as time goes on, they're going to be enhancing and maybe coming up with variations and so on. And you have to decide which of those do you protect and when. And what strategy do you use? Do you use a trade secret? Do you use trademarks? Do you use copyrights? Do you use patents? All of those things can come into play.
Got it. Okay. All right. So, third question here. Obtaining patents can be very expensive. What are the advantages and disadvantages to filing a patent in a country like China where they rarely defend our IP?
Okay, so the premise of your question is that if you get a patent in China, they won't defend it. Is that the
Yeah, like
idea?
you hear a lot of articles. I mean, you read a lot of articles about how, like, all these knockoffs are happening in China and all these other places. Like, is it even worth filing for patent protection in a country where a lot of that seems to be happening?
The places where you want to file a patent application and pursue patent protection are places where exactly that sort of thing could happen. So you want to block competitors from making and selling your invention in country. And the Chinese patent system is a little different than ours. It's come a long way. So a lot of people are finding that the Chinese patent system can help them. It's not. It's not just the nightmare stories that seem to get traded around. Now, having said that, the Chinese rules, Chinese patent law, is different than American patent law, and there are ways that local competitors can get around a patent and patent something themselves that aren't as accessible in the U.S. And some people are kind of working through how you deal with that, both at the government level in China and as people who are doing business there or having their product built there.
Okay. And the final question that we have, and then I think Demetrius wanted to talk to you a little bit about reform. If you invent something and you bring it to market and someone claims that they own the IP, but your patent has already been issued, what happens next?
Well, at that point, you're going to get legal representation. So this is very common. Patents. We often see the big cell phone makers going after each other on this point,
Yeah.
where a product is complicated as a cell phone, for example, or a car or an aircraft or something. It has many patents associated with it. It can be hard to figure out sometimes if a complicated product infringes some part of someone else's patent. So even if you don't mean to infringe, you might be doing it just because of the potential number of patents that cover the product. So in that situation, the point of the patent system, and this goes all the way back to the original writing of the patent laws, which happened with the Continental Congress in the United States, you want to engage in a negotiation with the other party and see if you can cross-license. And that way you're going to avoid litigation, and you're going to be giving each other permission to use those aspects of the patents that you both need in your own markets. And cross-licensing is a perfectly normal and routine and valid thing to engage in.
Awesome. Thank you. All right, Dee, I know you had some questions here about IP reform.
Yeah, so we all know that the patent system has been great, but it also hasn't been perfect. One of the things I've been hearing a lot recently is about a concept called the IP economy, especially amongst like investors and VCs. And it doesn't seem like it has an actual real definition yet. It's still kind of an emerging concept. What are your thoughts, since you work so closely with IP, on this concept of an IP economy?
Well, I'm kind of running into the same problem you do. I don't really know what people mean by it. So what I can say is that the number of patents that's filed every year has continued to increase almost exponentially since I started as a patent agent. And what's happening is IP protection is becoming an essential part of product development strategies where you're approaching markets with substantial economic value in them. Because you have to defend the upfront investment of time and people and money to develop those products. And right now, patents are how you do that. If you don't have the patent, you still have other things that you can do, trade secrets and stuff like that. But those don't work if your invention, the details of it are discoverable just by looking at it. So what's happening is patent reforms are trying to address this problem where really, really big companies will deliberately infringe because the penalties are too small to stop them.
Yeah.
So you see this with when the big cell phone guys fight with each other. They're talking about markets that are so huge and penalties that are so tiny that that they will deliberately infringe and just pay the fees.
Oh, wow.
But a small company can't do that. So this is one of those areas where people are talking about reform. Can we find a way to block a competitor who's big enough that they can just pay the court cost and just keep doing what they're doing?
Does that mean like the increased possibility of like injunctions on large companies like that?
Yeah, I'm not really in a position to get into that.
Mm-hmm.
There's once you start talking about those kinds of tools, that's out of the scope of what I would do with a patent office.
Sure. Well, on this topic, we know that there's no regulatory agency that's actually enforcing patent protections once they're issued. Like you have to litigate on your own.
Yeah, there is only one. There's one thing that I guess approaches this, and that is if somebody's importing a product that infringes your patent, you can get the Commerce Department to stop the import.
Oh, that's really interesting. I think I've heard of something like that with like Qualcomm bringing in chips or one of their competitors, maybe.
Yeah, there's still court activity involved. There's still a court decision that has to be rendered. But once it's rendered, you can actually have the thing blocked.
Okay. You mentioned
And the government does that. I mean, it's not like you have to go to the port and inspect the containers.
yeah. You mentioned that the number of patents that are being applied for and issued is going up right continuously at this point. Do you know if there's a corresponding increase in litigation around protecting those patents, or is that not happening?
Well, I go to a patent law conference every year. So to get an update on patent laws and court decisions and so on, I'm not really competent to discuss those court cases. But I can say that, yes, there's as the patent laws have changed, so has litigation. And people do vigorously litigate to defend their patent rights. After all, that's how you enforce. That's the enforcement mechanism for the patent.
Absolutely. Was one of the things that struck me was that when we're getting into this concept of an IP economy, it seems because the mechanism of it is litigation to some extent, then it's only accessible to people who have the capital to engage in that litigation.
Well, that's part of the business strategy for some of the people who receive such lawsuits.
Mm-hmm.
But a lot of times, what can happen is that once the attorneys start talking to each other, a plan for a credible lawsuit is presented,
Mm-hmm.
a negotiation starts. Mm-hmm. And sometimes those negotiations just end up with cross-licensing before it ever gets into the big battle.
Okay. Yeah.
But, sometimes the other party has to understand that this is a serious matter.
Mm-hmm. But for anybody who's maybe an individual and not a corporation, then they should understand that if that were to come up, they're gonna have to have budget for some kind of legal representation.
Yeah, they're going to need legal representation for sure, and this and for the same reasons that you need representation with a patent professional when you're going through the patenting process. It's just too complicated. You could do some of these things yourselves, but there's too many pitfalls.
Yeah, absolutely. We've talked a lot about litigation. Are there any other changes aside from litigation that you think might come down the pipe, even spitballing, like as far as the patent process, or maybe somebody trying to open up new ways to patent software or other systems?
Well, in my practice areas, software is becoming a core part of every product.
Mm-hmm.
So it's very it's pervasive. There's a lot of innovation that goes into software, a lot of expense into software development. It's not always possible to hide what the software is doing. So we have simply got to find a way for the patent system, not just in the US, but this is a global issue. We have got to find a way to recognize what the real sources of innovation are right now and not just think of them as, pulleys and gears and transistors.
Mm-hmm. That I think would be very interesting. Is there a lot of talk, like when you go to the conferences around it?
Oh yes, this is especially the conferences I go to are often held right at U.S. Patent and Trademark offices. The USPTO makes meeting space available to professional organizations, and the reason they do it is that they want their staff to participate in these conferences. And boy, do we get into some interesting exchanges.
I can imagine. One of the things that keeps coming up in my head, Phil, is that, well, what happens if we just get to a point where we say, if you don't commercialize your product, your patent expires? Like I've been thinking about this for years. Like if after 5 years or 10 years, let's say maybe it's halfway through the patent process, because you said it's like 20 years, right? And you're just not doing anything with it. We just say, okay, you're not doing anything with it. So it's fair game for anyone else.
That's already built into the system. Okay. So right now, after you pay the issue fee when you get a notice of allowance, a notice of allowance means you have claims that are in allowable form. You've basically won the combat with the examiner, and they're going to allow a patent to issue. At that point, you have to pay an issue fee. If you do not pay the issue fee, the application is abandoned and is dedicated to the public. So there's your first decision point. You don't pay the issue fee, you're not going to monetize it. Maybe your market changed during the time it took to prosecute the application, or something else happened. Mm-hmm. You just don't pay the issue fee. It won't ever issue as a patent, but it still serves as blocking prior art to other people. Let's suppose you pay the issue fee. That's what most inventors do. At least in my case, around 90% of them.
Okay.
Now, at intervals after the patent issues, you have to pay a maintenance fee. And a maintenance fee keeps the patent in force up to the 20-year expiration lifetime of the patent. Now, that 20 years is hard. It is more complicated to figure out when a patent expires now than it used to be. But just think of it as 20 years from the date of the very first application, with some adjustments. 3.5 years after the patent issues, you have to pay a maintenance fee. If you don't pay the maintenance fee, the patent expires. At 7.5 years, you have to pay a second maintenance fee, and at 11.5 years, you have to pay a third maintenance fee. If you don't pay the maintenance fee, the patent expires. So if you've got a patent that you're not commercializing, you don't plan on pursuing it with some future related product, just let the thing expire.
Just let it expire. Okay. Yeah, it's
kind of built into the system that if you're not commercializing it, just don't pay the fees.
That makes a lot of sense. And because, ultimately you don't want to have just like tons and tons and tons of patents just sitting out there doing nothing forever and blocking inventors from wanting to create products and bring them to market.
Yeah, but there's a kind of a premise there that I'm not sure I agree with. And this is what the purpose of the patent system is. And you can go all the way back to the way the patent laws were written during the Constitutional Convention. Purpose of the patent system was to get inventors to disclose how their inventions work so other people can improve on them. They want technology to advance, and the only way technology advances is by teaching other people what you did. So to get a patent, you have to teach other people how to make and use your invention. And in return for that teaching process, you get an exclusionary right for the lifetime of the patent. After the patent expires, anybody can use it.
That's why you see a lot of products come out at a certain time period, and then they're basically copies of everything that, was already in the market. And my assumption when I see that is like, oh, the patents must have expired. So now everyone's.
It could be, or it could just be that that the patent owners have decided not to pursue that aspect of the business anymore, and they either drop the license fees or they just make them very low.
Yeah. Well, Phil, I feel like we've covered a lot here today, and I know we can talk for like 2 more hours again if we if we want to do. There's like so much to cover here. I wanted to ask you your final thoughts before we sign off. Like, what is your big takeaway for our listeners, like people who are thinking about inventing things and thinking about patents and thinking about their future as inventors? Any final thoughts or ideas that you can provide to them?
Yeah, I would like to. I think I was thinking about this when you talked to me about the podcast. I think I want to wrap it up the way I wrap up my seminars, and that is what inventors should keep in mind when they're trying to decide if they should do this. The rules and the procedures for filing patent applications and for pursuing them through the patent office are complex and they're time sensitive. And the actions taken by the inventors and other people can bar your right to getting a patent. It can increase the cost of getting a patent. It can prevent a patent from even issuing. It can really seriously impair a patent's economic value. It can render a patent unenforceable if you get it. So this is an aspect of business where a kind of do-it-yourself approach can really lead to serious wasted resources and missed opportunities. And I really strongly suggest to people who are considering IP protection for an invention, don't try and do it yourself. Find somebody that you trust, a registered professional, and work with them as soon as you have some concept of what the invention is. Because those early meetings, a lot of times they don't cost very much or nothing at all. And you can at least get some professional feedback on whether or not you should do it.
Awesome. Well, thank you. Thank you again, Phil. If somebody wants to get a hold of you and have you help them with their patents or their ideas, what is the best way to get a hold of you?
I would direct people who want to contact me to go to the website for GSS Law Group, and that's gsslawgroup.com. GSS Law Group is all one word, no spaces.
Okay.
You'll find my contact data there and the lead attorney.
Awesome. Well, Phil, this was fascinating. And every time we talk, I feel like I learn more and more and more. And I know that you're every year learning more and more and more. So I really appreciate you coming. And I really appreciate all the listeners of this podcast. We hope that you're enjoying the content. If you have not done it already, please subscribe to our podcast on your favorite podcast player. And we will see you all next week. Thank you.
Thank you.